Greetings from the Department of DebEducation. I'm Dr. Deborah Duncan Owens, literacy education professor, researcher, and above all, a teacher with more than 30 years on the front lines of education. I appreciate you for tuning in to my YouTube channel. If you like what you hear, please be kind enough to hit the like button and subscribe. 504 is a serious topic. There are wolves in sheep's clothing lurking about everywhere, licking their chops as they seek to devour sacred rights. And with all the bizarre actions that impact education churning these days, there's something happening that has dire implications for all Americans. In September 2024, 17 states filed a lawsuit against the Department of Health and Human Services to challenge Section 504 of the Rehabilitation Act. Now, teachers and school administrators are well aware of the importance of 504 plans that are put in place to provide equitable educational opportunities for students. Now, like IEPs, 504 plans facilitate the development of accommodations for students who have conditions that create limitations in life. These can include learning disabilities, mental or health conditions, or chronic illnesses. While IEPs generally focus on conditions that directly impact learning, 504 plans are implemented in order to provide equity and access, opportunities, and the ability to thrive in various conditions, not just in the classroom, but also activities like field trips and after school activities. Now, let me make this real for teachers and parents. Does a child have asthma? Section 504 of the Rehabilitation Act enforces their right to have their medication available at all times. Does a child have a severe allergy that can cause an anaphylactic reaction? Section 504 ensures that foods are properly labeled and the threats caused by exposure to foods that can cause a reaction are eliminated from their learning environment. How about a student who experiences severe injury or illness? 504 ensures that they can continue to receive an education, sometimes with teachers going to them during the period of time they cannot attend school. Of course, parents with children with persistent disabilities understand all too well what 504 means for them and their families. But Texas, Alaska, Alabama, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Louisiana, Missouri, Montana, South Carolina, South Dakota, Utah, and West Virginia are asserting that Section 504 is unconstitutional. I know that sounds unbelievable, but there it is on page 42 of the lawsuit proceedings. What has these states all worked up to the point that they would want to completely eliminate the civil rights of so many people, including children? Well, according to the lawsuit, this massive lawsuit is because the Biden administration included gender dysphoria as a qualifying condition for protection under 504. And because of these two words, this one medically recognized diagnosis means what? I mean, anti DEI, homophobia, anti democratic, anti civil rights. I mean, where will it end? Will it even end? And 504 is a civil rights issue. It provides that no otherwise qualified handicapped individual shall, solely by reason of his handicap, be subjected to discrimination under any program or activity receiving federal financial assistance. As Stephen Walker of the Orlando Sentinel explains, more than 1.6 million students in the United States, including those with ADHD, autism, dyslexia, and chronic health conditions like asthma, have 504 plans in place that allow them to receive accommodations in class. He reports, while in the original lawsuit filed in September, the states asked the court to declare Section 504 unconstitutional. But in a brief filed last week, they said that was not their intent. Instead, they argued that Section 504, as updated by the Biden administration, violates Congress's spending authority, and they want a ruling based on those arguments. Walker further reports, however, Claudia Center, the legal director of the Disability Rights Education and Defense Fund, said the new brief was very conservative and very anti-civil rights and did not mean that the states had abandoned their 504 as unconstitutional argument, despite the legal posturing made in the document. Her organization and four others warned the state's new brief does not change anything about the case in a joint statement issued Friday. This legalese means that what they are saying is that Section 504 should only protect people against discrimination and a small handful of programs funded under the Rehabilitation Act, like vocational rehabilitation services, and not in the many other areas where Section 504 has always been applied, like healthcare, education, and housing, the statement read. And to be sure, with all the DOGE initiated funding cuts in departments like the Department of Education and the proposed elimination of the department, there will be many, many students and families hurt. The majority of the school districts in our country have a shortage of special education teachers, and it's not going to get any better. Thank you. More to come.